Welcome to the Real Estate Espresso podcast, your morning shot of what's new in the world of real estate investing. I'm your host, Victor Menashe. On August the 7th of this year, the Supreme Court of British Columbia delivered a decision that has captured international attention, both in Canada and indeed any country that has its legal system based on British common law. That includes the United States, with the exception of Louisiana, which is based on French civil code. In the case of Cowichan tribes versus Canada, the British Columbia Supreme Court recognized that the Cowichan tribes had established aboriginal title over a significant area of what is now a suburb of Vancouver called Richmond, British Columbia. It's overturning long-standing assumptions about who held ultimate title rights to land. The case is historic for several reasons. It's the first time a Canadian court has declared that aboriginal title exists over land held in fee simple under the Torin system of registered property rights. The judgment also rejects the notion that the provincial land registration system alone can extinguish aboriginal title, and held that where aboriginal title exists, it is senior and prior right to other property interests. To understand the implications, legally, socially, and economically, it helps to unpack what the court found, what it did not find, and why the result has prompted both urgency and uncertainty in both British Columbia and beyond. The Cowichan tribes, along with allied First Nations, initiated a land claim in 2019 seeking a declaration of aboriginal title over their traditional village site and surrounding territory on the south arm of the Fraser River, an area that's heavily urbanized and integrated into the city of Richmond, British Columbia. After the longest land claim trial in Canadian history, spanning over 500 trial days, Justice Barbara Young ruled that the Cowichan Nation had in fact established aboriginal title to about 750 acres of land. The court found that the historical occupation and connection to the land, supported by oral histories and other evidence, met the constitutional test for aboriginal title. Importantly, the court also held that many grants of land in the claim area, including those issued in fee simple, were constitutionally defective and invalid because they were issued without authority and unjustifiably infringed aboriginal title. So exactly what did the court say about private property rights? One of the most misunderstood aspects of the ruling is its effect on deeded private property. Some of the newspaper headlines and political statements have suggested that the decision puts native land claims ahead of private property rights, or it could lead to private property owners losing their homes and businesses. The legal reality is much more complex and nuanced. The court recognized aboriginal title as a prior constitutional right, but it did not automatically void the fee simple title of individual property owners. In fact, the Cowichan tribes never sought to have the private property landowners' title invalidated, and the judgment did not order that private property be seized or transferred. The ruling did declare that the provincial land registration system did not itself extinguish aboriginal title, meaning registered title alone cannot be the final word if aboriginal title is established. This has significant implications for how land law and Indigenous title intersect. The court stressed that negotiation and reconciliation between the government and the Indigenous nations are necessary to harmonize aboriginal title with the existing third-party interests, rather than abrupt or unilateral invalidation. So in short, the ruling recognizes aboriginal title as a constitutionally protected interest that predates other rights, but it does not mean that all private property within the title area automatically becomes Indigenous land. The legal mechanisms and political processes for reconciling overlapping rights remains completely unsettled, and it's the subject of an ongoing appeal. The decision, not surprisingly, ignited a firestorm of debate across British Columbia. Some private landowners and local officials have expressed alarm, saying that the ruling has created uncertainty for mortgages, for development, and real estate transactions on affected properties. Homeowners in the city have voiced concerns about title clarity, financing risk, and planning permissions. In the wake of the decision, some development projects have indeed been cancelled. In response, the provincial government announced it would seek a stay of the ruling and appeal to a higher court to clarify whether aboriginal title and fee simple title can coexist. Presumably, the only court remaining would be the Supreme Court at the federal level. At the same time, Indigenous leaders and legal analysts argue that much of the public fear stems from misinformation or misinterpretation of the judgment. They emphasize that the Cowichan Nation has not sought to remove private owners, and what the court called for was a fair process of reconciliation and negotiation, consistent with constitutional protections for Aboriginal title. Public opinion polls suggest a divided public opinion, with many residents expressing concern about the broader implications for property markets and legal certainty, while others view the decision as a necessary step in reconciling and righting some of these historic wrongs. British Columbia is unique in Canada because much of the province's land consists of unceded territory, meaning these are lands that were never signed or subject to any historic treaties. These Indigenous title claims remain unresolved across vast areas. The Cowichan ruling, regardless of the outcome on appeal, has highlighted the reality that Aboriginal title exists outside the provincial land title system, and that reconciling historical Indigenous rights with modern property law is not just an abstract legal issue, but it's one with profound social and economic consequences. Now, for investors, municipalities, Indigenous nations, homeowners, probably title insurance companies as well, the case underscores the property rights in Canada are not solely defined by the land registry systems, but also by constitutional protections in historic context. So how courts and governments balance these is going to determine how land use and development will move forward for the next several decades. What it does is it generates a huge question mark and then punts the problem over to government to go figure out a solution. It does not provide the solution directly. It casts a big shadow of uncertainty and says, here's a problem, you guys go figure it out. This case could open an avenue for future land claims in other jurisdictions, whether they be in the U.S. or any part of the former British Commonwealth. As you think about that, have an awesome rest of your day. Go make some great things happen. We'll talk again tomorrow.